same phone records again for some specific information?
Correct.
Okay. And what were the dates, or what was the date range of cell site location information you were asked to look at?
It was roughly 6 months of data. It was the end of November through June 2nd.
Okay, November of 2017.
November of 2017.
Okay, to June 2nd, 2018.
Correct.
Okay. And what was asked of you? What were you looking for?
I was asked to see if there had been any recorded cell site activity at cell site locations in Vernonia, Oregon.
Okay. And you've already testified a little bit regarding that North Wolf Creek public gun range and the towers that service that area. I think during that testimony you talked about some towers that could potentially service the Vernonia area. But for today's testimony, did you actually just zero in on Vernonia and look at towers that actually service the Vernonia area?
Correct.
Okay. And from looking at that, were you able to determine whether Nancy Brophy's phone ever was in the Vernonia area during that time frame that you said?
There were no records indicating that the phone had accessed cell sites in Vernonia
For the entire period?
for the entire 6-month period.
Okay, thank you. That's all I have.
Right, cross-examination.
Thank you. So you said you were zeroing in on the Vernonia area. Can you tell us what that means?
Yeah, so I referenced again the NDCAC database for cell site locations to look at what cell sites or for AT&T were present at that time period. And there was a cell site location roughly half a mile from the city center of Vernonia, which I would believe to be the primary tower for that area. And then there was another tower on Highway 47, roughly 4.5, 5-ish miles as the crow flies from Vernonia. So kind of in between Highway 26 and where Vernonia was. So those were the two towers that I primarily looked at. The only other tower that was within 10 miles was the one that could possibly service the public shooting range.
Okay, so there were two that we were looking at that were on either side of the public range, and the one to the east is the one you're talking about now? Oh, that's right. East and west is problematic. Away from the ocean.
The one that was on Highway 26 was the one that I believed would most likely serve, and that would have been east of the shooting range, and it would be considered, I guess, west of Vernonia. It's west of 47.
Okay, do you remember from looking at the map about how far Vernonia is off of 26? It's to the north, right?
I did not measure it. I know that the tower that was roughly halfway between 26 and Vernonia was about 5 miles. So if I was to give a rough estimate, I would say roughly 10 miles as the crow flies. Not sure, the road is a little curvy, so.
Okay, so the tower that's almost in Vernonia proper, within city limits, and then the one that's about halfway up from 26, and that's 47 that runs from 26?
Correct,
Okay.
yeah.
And then you think you looked at the other one that we had been talking about a couple days ago?
Yeah,
too?
I looked at that one, and that's on Highway 26. So I would not consider that due to distance, other towers being closer to Vernonia, and geography. I would not consider that to be a primary tower for Vernonia.
Okay, so when you talk about Vernonia area, you're talking about maybe sort of 5 miles around Vernonia?
Correct.
I'm
Yeah,
gathering that from what
a
you're
radius,
saying.
yeah.
Okay, all right, but not all the way down to 26, not south of 26. Okay. Did you, while you were looking at that, or can you tell us how many times her phone was in, for instance, Buxton, which is another one of the little towns around there?
No, I can't. I primarily was looking at that 5 mile around Vernonia.
Okay, so is that, you can't tell us about Timber either,
No,
or Banks?
no.
All right, now, I think you said that the records that you were looking at were for about a 6-month time span, is that correct?
Correct,
November of 2017 to June of 2018?
correct.
If you had wanted to look back to, let's say, the summer of 2016, did you have the ability to do that?
No.
And then,
The
is there any way
data that I was given began November of 2017 from the search warrant.
Okay, so you feel pretty confident saying that she, at least her phone, maybe not her, but
Phone.
she, with her phone, was not present in the city proper of Vernonia during that 6-month period.
Correct, based on the records.
Okay, but you're not saying that she wasn't in the broader area. Let's say you were looking at a 18-mile circumference around Vernonia. You're not speaking to that today.
I'm not, no.
Okay, and you can't go back before November of 2017.
Correct.
I think that's all I have. Thank you.
Thanks.
All right, redirect if any.
Your Honor, I can of course recall Ms. Guay so that they can have a chance to recross, but I did have one other question that I didn't cover. I don't know how you want to handle that. Of course, I would offer that they be able to ask questions.
All right, I'll allow you to ask the question, and if defense wants to cross-examine based on the question, defense will be allowed to cross-examine.
Thank you, Your Honor, and apologize. Ms. Guay, I'm sorry, I forgot to ask you, were you provided an address that was associated with somebody named Delilah Marvell?
Was provided an address in roughly the Banks area.
Okay. And yeah, I might not have given you the name, but provided an address in kind of the Forest Grove Banks area.
Yeah, like Gales Creek maybe.
Okay, Gales
Yeah,
Creek.
Yeah.
And did you look for towers that serviced that area as well?
Yeah, it was a couple weeks ago.
Sure.
But I did do like a brief review of that area.
Okay. And same question, in the time frame that we've been discussing, did you look to see if Ms. Brophy's phone appeared on a tower for that servicing that area?
I'm not sure if I looked specifically to see if there was activity. I looked to see where the closest tower was, and there was one roughly 1.5 miles from that address, an AT&T tower. So I can't speak if there was ever activity on that because I wasn't specifically looking at that. I was just looking to see if there were towers in the vicinity.
Specifically, were you looking to see if the tower that would service that area was any of the towers that you had previously spoken of on Highway 26 that was showing activity?
Yes, yeah, I was looking to determine the distance between the closest tower for the address.
Okay, and those towers that were along 26 that you have previously testified about, were any of those towers the tower that you identified that would most likely service that address?
They were not the closest. I can't remember the exact distance, but there was a tower, I believe it's on that Highway 6, that is more in like Banks area, that was like 1.5 miles roughly, which seems like it would be the most likely tower to service the area.
Okay, that's all I had. Thank you.
That's one I recross.
Just a couple follow-up. So to reiterate, though, you didn't check to see whether during that 6-month period, and of course you can't go earlier than that, so we're limited to November of 2017 forward, but you didn't check to see how many times she was in Banks?
No, I didn't look to do like a pattern of life on that. I was just looking for towers in the area specifically. So again, using the NDCAC database.
Right, so you're not speaking to whether she was in that area. Her activity on those towers is not a part of what you're addressing. You're just talking about whether you could have done it.
Yes, yeah.
Yeah, okay, good, thank you.
All right, may the witness be excused.
Yes, sir.
All right. And then the state's next witness.
The state will recall Brian Wilkie.
Okay. All right, Mr. Wilkie, we'll just have you come back up to the witness box like before, and once you step in, stay standing. My clerk will give you an oath.
I'll ask you to please raise your right hand. Under the penalty of perjury, do you solemnly swear or affirm that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, then you may be seated, and I'll ask you to please state and spell both your first and last name.
Brian Wilkie, Brian Wilke.
All right, it'll be just 1 second, Mr. Wilkie. I think they're setting something up.
Sorry about that, Mr. Wilkie. All right. I want to take you back to June 2nd of 2018. And we talked about this a little bit on when you were up here before. And you mentioned that at some point while you had arrived at OCI that you saw Nancy Brophy arrive at the scene. Is that right?
I didn't see her arrive, but I did see her.
Did she just kind of appeared from somewhere?
Well, I was busy taking care of a lot of things, and I was walking up 17th Avenue with Tom Bethel, and we were in the process of getting the students out of the school over to our administrative offices. And I came up 17th Avenue, and that's when I saw Mrs. Brophy.
And so where was she and who was she with?
She was standing behind the police tape on the northeast corner of 17th and Jefferson, right outside of our little corporate office over there. And behind her was Woody Bailey.
Okay, so he was standing on the same outside the tape as she
Outside the tape, probably 6 feet behind Nancy.
Okay. And can you, so I assume if we're can you see that map from where you are?
Not really, but I'll figure it out.
Do you see OCI there in red? And so is the corner you're talking about across the street from
Yes.
the corner of OCI that's on 17th and Jefferson?
Yes, it was.
Okay. And was it at that time that you talked to Ms. Brophy? Or did you?
Yes.
Okay. And so you walked up to her?
Yes.
And was Woody Bailey there the whole time?
Woody was there the whole time. At that time, Woody was out in the gorge that day, and he had made his way back by that time. And like I said, it was chaos. So for whatever reason, we were over there discussing what we were discussing. That's when I saw Nancy and Woody for the first time.
Okay, and so you walked down 17th towards Jefferson to make contact with them?
Yes, ma'am.
All right.
Not Woody, just Nancy.
Just Nancy. Okay. And did you stay with her until detectives took her, or did someone take her into?
No, I lifted the tape. I walked up to Nancy, and she said to me, "This doesn't sound good, Brian." And I said, "It's not good, Nancy." And I lifted the tape, took her under the tape, put my arm around her, and started walking her towards the police vehicle, RV thing.
And did a police officer intercept you?
Officers approximately 3/4 of the way to the RV came, and I introduced Nancy, and then they took her to the van from there.
Okay, and did you walk off or stay there?
I'm sorry?
Did you walk away or stay like right where you were,
Well,
or both?
I stayed there for a short time, but then I had stuff to do, so.
Okay. And during that period, as you're interacting with Ms. Brophy, other than what she said, how was she?
What do you mean exactly?
Well, was she upset? Was she talkative? Was she quiet?
She was fairly normal, I would say. I was actually kind of surprised, but
Okay.
there you have it.
And then what about Woody Bailey? Did he stay there? Did you see where he went?
They weren't letting anybody through at that point. Woody was standing behind Nancy.
And how was he?
Tears were coming down Woody's face, and if you know Woody Bailey, he is not a crier.
And was he making any noise or sounds at all?
I didn't speak with Woody at that point.
Okay. All
I
right.
was just there to take care of Nancy.
Okay. And you didn't go back to where Woody was. You went
No.
somewhere else.
Correct.
Thank you very much. That's all the questions I have.
Okay.
All right, cross-examination.
Just a couple. Welcome back, Mr. Wilkie. Now, it's your testimony that it was you who picked up the tape and it was you who escorted her to the van?
If you want to see it, all the news channels had it on. If you just look at their tapes, you'll see it. I don't know which station it was. I don't watch television, but one of the stations had a camera pointed down 17th Avenue and clearly showed me lifting the tape and putting my arm around Nancy and walking her towards the police van.
I understand. Do you remember Officer Wells?
There was
A woman? Do
1,000 officers there.
you remember a woman officer who was with Ms. Brophy?
No. I just remember a woman officer who was at the back of the school that day.
Okay, but you don't remember Ms. Brophy standing with a female officer by the name of Wells?
No.
Do you remember another male officer who might have brought Ms. Brophy toward the tape?
When I saw Mrs. Brophy for the first time, when I saw Nancy, she was already behind the tape standing by herself, along with 100 other people.
Okay.
But no, I saw no officers over there.
So it was just you and Ms. Brophy?
I'm sorry?
It was just you and Ms. Brophy walking to the police van?
Correct. Like I said, there was 2 police officers who, I don't know where they were coming from, but I didn't walk Nancy all the way to the van. They came and took her from that point.
2 male officers or a man and a woman?
Don't recall.
Okey dokey. No further questions?
All right, any redirect?
No, thank you.
All right, may Mr. Wilkie be excused?
Yes.
All right, thank you, Mr. Wilkie.
Well, there you have it.
And state's next witness.
Yes, just one second.
All right.
Yes, Your Honor, the state will call Clorinda Perez.
Okay. All right, Ms. Perez, we'll just have you come back to the witness box just like before and go ahead and step into it, but don't have a seat just yet. My clerk will give you an oath.
I'll have you step a little closer to the microphone if you can. You can move the chair if you need to. Thank you. And please raise your right hand. Under the penalty of perjury, do you solemnly swear or affirm that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can go ahead and take off your mask and you can take a seat.
Thank you.
And then because we're being recorded, I'll ask you to please state and spell your first and last name.
Clorinda Perez, CLARINDA PEREZ.
All right, when you're ready.
Ms. Perez, you've already testified in this trial, is that correct?
That's right.
Pretty early on, very
Yes.
early on? Okay. I just want to make sure to reorient you with the jury, so I'll ask you a couple questions that I may have already asked you, but you were attending the Oregon Culinary Institute back on June 2nd, 2018?
Yes.
Okay. And you actually went to the school that day?
Yes.
And do you remember how you arrived?
In my car.
You drove?
Yes.
And where did you park?
In the school parking lot.
And which door did you go into?
The student entrance.
And where did you go once you entered the building?
Initially, I went into the established classroom to drop off my belongings.
Okay. Once you dropped off your belongings, where did you go?
I went to the coffee station to grab coffee, water. Noticed.
I'm thinking this is just a replay of earlier testimony and not appropriate rebuttal.
All right, let me, in order for me to rule on that, I am going to have to ask the jury to step out for just a moment.
All rise for the jury.
And Ms. Perez, what I'm also going to do, and I apologize to this for you, but I'm going to have you put on your mask and step down from the box. And if you could just wait back outside for one moment.
I think
So what point or fact in the defense case has Ms. Perez been called to rebut?
A couple of things, Your Honor. One, her interactions with Miss Brophy at the Side Yard Farm. I had asked Miss Brophy if she remembered seeing Miss Perez there.
At what farm?
It's called the Side Yard Farm. A memorial was held there in August of 2018.
Okay.
Miss Perez attended, and she had an interaction with Nancy there that I think is relevant.
Well, when you say relevant, and I'm gonna, I haven't memorized all the testimony over the weeks that we've gone.
Okay.
What specifically was said either by Mrs. Brophy or someone else
Right.
that she's going to be rebutting?
And I don't want to misquote either, Your Honor, Miss Brophy's testimony, but I believe what she said was that I think she said that she spoke with Miss Perez at that event.
Okay.
And maybe not at that event. I guess what I need to clarify, the crux of what's coming out with Miss Perez is that Miss Brophy talked about Miss Perez speaking to Miss Brophy about her life-saving measures, her life-saving efforts. And I believe this evidence would rebut that they had that conversation.
Let me make sure I'm
I know.
following. You're saying Ms. Brophy testified that Ms. Perez had talked to Ms. Brophy about the life-saving measures that Ms. Perez had taken?
Yes,
And now Ms. Perez will be saying, no, we didn't have that conversation, essentially.
among other things, for context, yes.
Okay, you say among other things, what other things?
That she attempted to talk to Miss Brophy about it, and Miss Brophy wouldn't even look at her and would ignore her.
Okay, all right. So far, I will say this, Ms. Maxfield, and so far what we've heard is not rebuttal, although I think a question or two just to orient the jury as to who she is appropriate, but I would be inclined to sustain your objection to the extent that we move on to what the actual area of rebuttal is. Anything more that you would?
Moving on to the area of rebuttal, though I think it's really not rebuttal. That was not part of the defense case. She was the counsel invited that response on cross-examination, but that was not a part of the defense case. Counsel's now rebutting evidence that he elicited and not anything. Yeah, and he never asked our client whether she ignored Ms. Perez.
All right, well, here's what I'm going to do. I'm going to go back and, as I've said before, I take fairly extensive notes. I will review my notes on what Ms. Brophy said and whether it came out in cross versus direct. So why doesn't everyone have a seat? And it's going to take me a moment to do that. We can go off the record for just a moment.
Your Honor, did you want me to address the other issues?
Oh, what other issue is there?
Well, she's testifying to more than that. Part of the line of questions that I'm going through right now, one, it is to just kind of remind the jury who she is, but also we're rebutting their expert testimony about memory as well.
How?
This is because Ms. Perez attempted life-saving measures on an individual and was unsuccessful. Dr. Reesberg talked about how that is an extremely traumatic event for an individual, but yet Ms. Perez doesn't seem to have an issue remembering the events leading up to and of what was happening. So her testimony about...
I think that's an argument. I don't think that's true rebuttal in the sense that she's already testified to having memories of that day. Is there some specific memory question you want to ask her?
Well, I don't know that, I'm unsure, I should say, that I asked her how she arrived that day and where she parked. So I was just trying to get those details. I'm trying to move very quickly through these questions because I don't want to spend a lot of time on them. My next question was entering, did you provide life-saving measures to Mr. Brophy and were you successful? No, and then I'm moving on.
Well, okay. They have clearly already heard that testimony, and frankly, I don't know how that question rebuts anything. I do want to look at. I do think I will also say that when it comes to rebuttal evidence, I think it's proper to rebut things that come out in direct, but not necessarily something that comes out in the first time in response to a cross-examination question. I don't know whether or not this whole issue of the conversation at the Side Yard Farm came out in direct or cross-examination, so I will look at that.
It was on cross. I would admit that, but I think that we can rebut a defendant's answer.
Well, but it's, all right, I'll look at one thing before I make a final ruling on this, but I generally think rebuttal is to rebut evidence that defense is putting on or eliciting, not evidence that comes out in response to a cross-examination question. I mean, that's one of the dangers of cross-examination, is asking the question you don't know the answer to. But I will take a look. But let me just make sure I have them. So the rebuttal, the potential rebuttal is this issue with the conversation at the side yard about at the side yard farm, and then the issue of that she has a memory of what happened that day. Is anything else?
I don't believe so.
All right, we're going to take about a 5-minute break. I just want to look at one thing.
Okay, go off reference and we'll be in recess. All right.
All right, please be seated. I confirmed that I thought earlier, but I'll state it more articulately now, which is rebuttal evidence is evidence that contradicts or rebuts the evidence that was presented by the opposing party. I don't think it applies to information that comes out for the first time under cross-examination, which had not been offered by the other side. So I am going to sustain the defense objection. Before we call for the jury, are there any other state's rebuttal witnesses?
No.
And then before we call for the jury, I know there's an issue as to defense rebuttal witnesses and the state thinking that at least some of them, I said rebuttal, I meant surrebuttal, thinking that some of them weren't appropriate, but I don't know what the defense surrebuttal witnesses are for. So what, tell me who's being objected to so that we can at least have a discussion before the jury comes back.
Sure. And so the list of witnesses begins with Rich Hersey.
That's the investigator, right?
He's the investigator. We didn't necessarily have an objection, but I think maybe some clarification. He's going to talk about the layout of the jail dorms.
Okay.
I guess if they're alleging that it's contradicting what Ms. Jones said, we don't have a problem with that.
Sure,
I think that makes
sure.
sense. But if it's just to further show what a dorm looks like or something, then that doesn't really make any sense. Wouldn't be relevant.
I'll just ask defense.
Your Honor, he was given permission to go in and take photographs on the inside of Inverness and MCDC. It was unclear until Ms. Jacobs testified which facility she was speaking to. She did say yesterday that it was Inverness, and so we would like to present these photos to show the proximity in which the inmates, first of all, are to each other, just so the jury can kind of visualize how that is laid out, but specifically, we're focused on where the telephones are and where the attorney phone is in relation to the general layout of the jail and where the other inmates are. I will admit that until this came up, I always thought that the attorney phone was in a much more private area, but it's not. It's right out in the middle of the room, and I think it's important for the
But what
jurors.
is it rebutting? That's what I'm getting at. What did she say that this evidence would rebut?
Well, she's claiming that she and our client,
Private conversation.
huh?
She's claiming they had a.
Right, she's claiming that she learned this from her client in a private conversation, and that she didn't learn it by overhearing something that Ms. Brophy said to someone else. And I think that this evidence is important to provide context that there's basically no privacy, including there's no privacy when somebody is talking on the attorney phone, so that the jurors can understand as further testimony is developed that she had other sources for information about Ms. Brophy beyond those she described.
She did, I will say, Mr. Overstreet, and I don't remember the precise comment, she did make something along the lines of when defense asked her whether or not it was easy to overhear what was being said on the attorney phones, that she essentially indicated unless you're right up next to them, you wouldn't be able to hear it. I don't know if that's true or not, but I guess I'm inclined to allow it. Anything more you want to say?
Yeah, Judge, the same issue we just dealt with, and that is it came out on their questioning on cross, not on direct.
I'll take a look at that then.
Do you want me to move on to the next witness?
No,
Oh, sorry.
I want to look at. Well, yeah. Why don't we go through all of them? All right.
Okay.
Go ahead.
The next witness they intend to call is Rosalind Lee. It's listed in their email as a federal and state practice fraud guidelines representing cooperators. I can't imagine the relevance in that. I think she is a lawyer. That's all we know.
Okay. Defense.
Oh, but we're talking about Rosalie now. Okay.
Rosalind?
I thought it was always Rosalind.
I'm just reading their email.
Oh, yeah.
So, Your Honor, with respect to both Rosalind Lee and Aaron Jeffers, they are both attorneys who can speak to a number of issues that are relevant here. Ms. Jacobs essentially disavow any knowledge of benefits that might come her way and of exposure that she might have. We do not believe, for the reasons that Mr. Scott elaborated yesterday or the day before, we do not believe, I guess that was just yesterday, that we should be held to her response to those questions. It is not credible in our view that she has no understanding whatsoever of how she might be compensated for this. We do believe, based on the representations that Detective Merrill made to her and common sense, that she does have an expectation or a hope that something will be coming her way. And we have witnesses who I think can give the jury better insight into how that system works and what it is exactly that could play out in the future, even if it has not played out to this point, that could be heavily influencing her testimony and her bias. The fact that she doesn't admit to the bias, they just cannot, under current case law, restrict our ability to question her further.
Well, but when we're talking about bias, if you have extrinsic evidence that someone actually had the bias, I understand your argument. But if you're calling people to talk about things that potentially exist out there, but there's no evidence that she knows of these things, how does that how does that rebut anything?
I actually got the benefit of reading the Houston case, and Ms. Weinmiller didn't. But Mr. Scott urged us to read the case, and in that case, what happens is a CARES interviewer took the witness stand and was cross-examined by the defense regarding the ties between CARES as an agency and law enforcement.
Yep.
And the witness said, I don't know. I don't really know much about those things. I don't know who's involved in this. I don't know how that funding works. And the court said that it was proper under 609.1.2 for the defense to be able to introduce extrinsic evidence to establish that link between CARES and law enforcement.
Sure. That was someone who directly worked there, right? Who, I mean, who's saying she doesn't know about the connection, but she works there. She's an employee of CARES, right?
I mean, it's not, I'm not understanding why that would be a distinction. Here we have a witness who has exposure, criminal exposure for her conduct at the same time that she is giving a statement to a police officer who told her something of value was likely to come her way. And I think Ms. Weinmiller's right. The fact that she denies that she had any hope that something of value would come her way, and the fact that she would have been motivated by the potential exposure, it's not a theft too. Her potential exposure is dramatic and extreme, and the jury doesn't know that. In the same way that the CARES witness was not allowed to simply, kind of stall defense inquiry regarding potential bias, nor should Ms. Jacobs. The fact, and I don't know, isn't an answer that ends the, excuse me, I'm losing my voice.
No, go ahead.
That ends the inquiry.
All right, all right. So those are three people. Anyone else? Let me ask this. What's the difference between what Rosalind Lee would say about all this and Aaron Jeffers?
Well, Ms. Jacobs appears to have exposure on multiple fronts. There's this DOJ investigation, there's the potential bankruptcy fraud. Ms. Lee practices primarily in federal court. Mr. Jeffers works solely in Oregon state courts, and so they can each speak to the exposure differently. And then, of course, the practices with respect to how cooperation is handled and how it's rewarded are different in the two systems as well.
Okay, all right, and who else on the state side?
I'm going to complete my argument on that briefly.
Go ahead.
I promise to be brief.
That's all right. I don't want to cut people off on their arguments.
I appreciate that. I think this is different from the Houston case. I also had a chance to read that case, not just because the person worked there. I agree that obviously that person should probably know the structure, but it was to rebut the assertion that she was making. That's what the witness was being called for, not to attack their bias or their motive for testifying. It was being offered for a different reason. And the reason I'm differentiating that is because Ms. Jacobs is saying, I don't know. And I think there's evidence that actually would suggest that she doesn't know. That letter does not say you're being charged with X, Y, and Z. So because the DOJ has not even made a charging decision, how could you expect the defendant to know what their exposure is? And so I think that I'd ask you to consider that. The second part of that is, I think that's even more true for Rosalind Lee, because they're attaching that to that potential federal bankruptcy case that Ms. Jacobs said she didn't even know was an investigation. And frankly, we don't know if there's an investigation. So I think that she's even removed one step further than Mr. Jeffers. Also, this idea of cooperation, there is no cooperation. No cooperation agreements were made. That was testified to. And so to have somebody come in and explain cooperation agreements to the jury would have zero relevance. So I will end on that argument, Your Honor. The next person is Donna Maddox. We are not objecting to her.
Okay.
You've already made your ruling of the parameters of her testimony, and we just ask that defense stays within those parameters. Otherwise, we don't have any objection. The next person is a person named Michael Howard. He's listed as pretrial litigation. I don't know what that means, and I don't know who that person is, and I don't know his involvement in the case. So we're objecting because we don't understand the relevance, and we would object to his WebEx appearance.
All right, so there were two objections. One was the relevance, but that's in part because they don't know what he's going to testify to, but they're also objecting to an appearance by WebEx. What's the defense position on Michael Howard?
Your Honor, he's the criminalist who's testified previously in this case. He's been examined under oath. He used to work at OSP, and he worked in the gun part division of OSP. We did not recognize that his testimony might be relevant until this came up, and it turns out that he was already out of state when that testimony occurred yesterday. So we don't, given the rapidity with which this is developed, we don't have the ability to force him to come back, but he is willing to testify by WebEx, and we think given the unusual nature of the way this is developed, it's appropriate to allow him to testify that way. Certainly with all of these witnesses that are being challenged, given the state of appellate law, we want to, at the very least, make complete proffers
Sure,
about this,
sure.
including from him by WebEx.
And what, but just so I understand, because frankly, I don't remember him at the moment, what is he being called to rebut?
He, during, we are getting a transcript.
Oh, you're holding
What?
that down.
Oh, okay.
I guess before you answer that, let me say this, because I got the sense maybe the sides, I thought I articulated it pretty clearly, but maybe not. So here's what I see as the proper use of rebuttal. Normally, as you all know, defense doesn't get a rebuttal. However, the state was calling a witness, Ms. Jacobs, which the defense had very little time to prepare for, and I felt under those circumstances it was appropriate to call rebuttal witnesses to deal with her testimony, whether it be to impeach her due to her credibility issues or some other aspect of that. Does Mr. Howard play into this at all, or does he, or are you now trying to address something that was?
Sorry that we're tag teaming, but
That's okay.
sometimes one of us knows a piece of the puzzle, the other doesn't.
Sure.
Mr. Howard, if the court will recall, testified as part of the defense motion for destruction of evidence. Although she doesn't pin this conversation at any point in time, counsel has provided us with a time frame of March in 2021. What we know about March of 2021 is that we were preparing for the hearing on the motion for destruction of evidence. In anticipation of that, I was consulting with Mr. Howard, who was the defense expert, and also relaying to Ms. Brophy what we were learning. And we were learning that this second shot, what would have been a very short, I think a short distance away, and that he was the one who testified about the gunshot residue having gone missing from the front of the shirt, which was frustrating to Ms. Brophy. But I think his testimony goes to what was the defense team talking to the defendant about on that jail phone at the time of the supposed conversation with Ms. Jacobs?
So you're talking about the distance of the shooting.
Yeah, that we were
essentially.
we were actually having a conversation with our client about what we thought our evidence was going to show.
Okay, all right, now I understand that, on the state side of things.
How would Mr. Howard know what the lawyers are relaying to Ms. Brophy?
Well, I don't think that would be the question that would be asked, at least I assume not.
Well, if he doesn't know that, it doesn't matter what defense was working on at the time. You have to make the connection.
Well, I think he could testify as to the conversations that he was having with the defense team and what the nature of those conversations were. And argument can be made, but you know, the state is going to attempt to imply that because Ms. Brophy held her hands out in a certain way, it indicates that she knows that because she was there. I think it's fair for defense to rebut that inference.
But agreed, if they have the right witness to do it. I guess what I'm not understanding is Mr. Howard testifying and saying, I told the defense counsel that it was my belief that Miss Brophy, that the shooter must have been a certain distance away from the victim. Because then we're speculating that that information made it to her. I guess is the problem.
So let me ask defense that. Well, do you want to address that? In other words, does this witness have any knowledge or understanding that?
It would be malpractice. We're ethically obligated to share that information with our client.
But that's not an
And
evidence.
that's not a huge inference for any juror to know that lawyers talk to their clients about the important matters in their case, especially leading up to a hearing.
Okay, all right. Now, we can always have a 104 hearing to hear exactly what he would say, but I'll tell the state I understand the argument, but I also understand that, you know, having a witness this late in the game raises issues, and I'm inclined to, I guess, lean more on the side of caution to allow rebuttal evidence than to not allow it. And if all he's going to testify to is these are the conversation I had with the defense attorneys, I don't think it's a huge inference. I understand it's not an evidence. I don't expect the defense attorney is going to take the stand and say, I told my client X, but I don't think it's a huge inference that they would have had conversations about the case with their client.
I understand, Your Honor, and I would just ask that it be limited to that. Ms. Maxfield did mention some other things about residue and
Right,
how upsetting that was. And
I would say, Ms. Maxfield, I don't think there was any testimony at all by Ms. Jacobs about gun residue. So, you know, what we may have to do before and so let me say this too. Because of the nature of the way this unfolded, I understand the state's objection to a WebEx appearance. I'll allow a WebEx appearance, but I do think we'll probably need a 104 hearing so that we understand the parameters of what Mr. Howard can and can't say.
And I understand that, Your Honor, and I'm certainly not arguing. I just want to state why we're objecting to WebEx.
No, go ahead.
The only reason we're objecting to WebEx in these scenarios is that we haven't been provided any reason why it's necessary other than out of state, but they've had time to arrange that. They haven't stated that this person's unable to be here. And especially doing.
He would have been unable to be here even before, and I thought we had agreed that Mr. Howard could testify by,
Sorry.
she's got the
That's all right,
finger now,
it's all
but
right,
she's
go
got
ahead.
it down now. I thought we had agreed that Mr. Howard could testify by WebEx even before we began trial, because Mr. Howard is like 80 years old and was terribly worried about COVID. And I thought that Ms., and I could be wrong, but I thought there had been agreement because he had health concerns that he was going to be allowed to testify as part of the defense case in chief. So I didn't know that WebEx was going to be the big obstacle here. But we certainly can work to try to only give as much as is necessary so that a reasonable inference can be drawn. I think
when we say he's out of state, that could mean Vancouver, Washington. How far out of state is he?
He's in Hawaii.
Okay, all right. Okay, All right, I understand the objection, Mr. Overstreet. I'll allow the WebEx testimony. And I'm not implying that there was any agreement by the state that that would be allowable. But given sort of the fast-moving situation here, I'll allow for it.
And
Understood.
as we're sitting here talking about this part of the testimony that we would present, it could be that we need to put a very, very short Multnomah County Sheriff's Office witness on to talk about the fact that we weren't allowed into the jails right then. It was because of the COVID restrictions, that was only one way that we could communicate with our client.
What was the way you could, the
Couldn't
only
go,
way you,
we couldn't go visit our client.
okay. But what's
the
the
jail phone.
significance of that?
Well, that's why we're talking to her on the phone.
Oh.
I mean, usually we're smart enough just to go talk face to face so that we're
Okay.
not fighting
Okay, I
the jail
understand.
nonsense.
I think I understand. But you don't have a particular person right
But
now.
we're gonna grab any warm body that'll tell us about that,
Judge,
tell us about the restrictions.
Go ahead. Again, there's, an issue has been brought up through Ms. Jacobs as to whether or not conversations could be overheard regarding defendants and their attorneys on the phones. And she's essentially said, no, you'd have to be up really, really close. To the extent we're talking about evidence that can challenge that to some degree, I'm inclined to allow it, but go ahead and.
Sure, and I'm not attempting to argue against that necessarily.
Okay.
Just this idea of a sheriff's deputy to say you had to use the phones at that time.
I don't know if that's true or not. I mean, I'll just tell you, I don't know if that's accurate.
Okay.
So I don't know if there was some form. I just simply do not know if that's correct. If it is correct, that's one thing. If it's not correct, it's another.
Okay. So the next witness is Rhonda Slavic. She testified.
Oh yeah, I remember.
We have a couple of objections. One, they also want to do WebEx. We're objecting to that. And then just based on the content of her testimony last time, we had some significant concerns that she actually had any personal knowledge. She talked a lot about her brother's business and her family, and they all thought she was a liar, and they thought this and that. So I think.
Well, so let me say this. I agree, she did. But part of the parameters of what I'm allowing for is opinion based on reputation. From what I heard earlier, I think she would probably at a minimum be able to do that. But I guess I should ask defense what she's being offered for.
Her opinion regarding the witness's truthfulness, and I think she would also be able to offer her reputation, at least within the family community, regarding truthfulness. But if the court will recall, Ms. Jacobs told Ms. Slavic that she had cancer.
I do, I remember.
So that she could live in that, or that she could stay in that house. And then she doesn't have cancer. That's
I
personal
remember that that's
knowledge.
part of it.
How do we know that?
Oh, gosh.
Well, we can have a 104 hearing on her, but my memory from reading, I don't even remember what I read anymore, but so I could be mistaken. We can certainly explore her personal knowledge.
Okay.
Before she testifies.
And are you making the same ruling on the WebEx objection?
Yes.
Okay.
Well, I guess I should ask. I realize it's probably just because of the fast-moving nature, but I don't know where Miss Slavic lives.
She lives in California. Sorry, I've
Okay,
talked with her most
all right.
recently. She lives in California. We talked about flying her up, and the timing is an issue. One of the things is that her twin sons have their 18th birthday tomorrow, and she's
Okay,
hosting a party.
all right.
She did promise that she would be in front of a desk and a computer and not in a car, but I just don't think it's right to ask her to miss that.
No, I don't either, and I'm allowing some leeway given the way this whole thing is shaking out. All right, so that's Miss Slavic. Anyone
And
else?
the last one they have listed is Curtis Haney. I believe Your Honor already made a pretty clear ruling on Dr. Haney's scope of his testimony, so we don't have any objections to that. I just want to make a sort of a standard objection to going outside of your order based on some of the representations that were made in court. I do have some concerns that we just stay within that order.
All right, and I'll ask defense. I think you understand the parameters of my order, but again, if anyone doesn't, let me know. And of course, the state, if they hear anything they think, because look, the reality of witnesses is even when attorneys talk to them beforehand about what they're allowed to say and what they're not allowed to say, sometimes they stray. So it'll be incumbent on one side or the other to object if they think a witness is straying outside the parameters of my order. And I'm also getting the sense, just hearing the defense respond to some of these issues, that I'm assuming none of these witnesses are ready today. Is that a fair assumption, or are some of them ready?
Give Mr.
We
Hersey
need to
one.
put Mr. Hersey on. He's had a death in the family and will be
Okay,
flying out
all
early
right.
tomorrow.
We can
so,
certainly do that.
and Ms. Lee is here in the courthouse if we have time to get to her.
I'm going to
she-
have to take a look at Miss Lee, and I don't know if Aaron Jeffers is male or female, but I'll have to look at, I've got to look at a few things there. I will tell defense I'm far less confident about allowing those two to testify, but before I make a final ruling, I do want to review something.
And Your Honor, we understand that with respect to those two and perhaps the scope of testimony beyond that, but we do want to make proffers given
Of
the
course.
issues that Mr. Scott raised. So we're
Sure.
proposing that we at least put them on, and maybe we should do that first. and
Oh,
then the
yeah,
court
we can certainly do that.
Yeah.
Well, let me ask you, timing wise, you know better than I. Do you want to put Mr. Hearsay on first, or do you want to take a proffer first?
You call him Mr. Hearsay?
I said
He's
Hersey,
such a
or at least I
nice
meant to
man.
say Hersey. So if I said something else, I apologize, but I
It's
meant to say
okay.
Hersey.
Some words stick with us.
Your Honor, before I forget, before we officially rest our rebuttal case,
Yes.
I do need to offer to admit State's Exhibit 116, which is that jail call excerpt that I played with Miss Brophy.
I don't even, okay,
And it's just the excerpt, and it's only her portion of the audio.
what is said in it? I'm just trying to remember myself.
You're offering something that was played during when? We're in rebuttal now. Ms. Brophy testified as part of the defense case, and you're now offering an exhibit that was introduced during Ms. Brophy's cross-examination in your rebuttal case?
Yeah?
All right, in your position.
The case hasn't gone to the jury yet.
Okay, I think what's being argued, without actually hearing I'm just gonna, go ahead, Miss Maxwell, make your argument on
Well,
it.
I just don't, I think that the time to admit that exhibit was while the case was outside at the rebuttal portion. The state didn't offer that exhibit as a rebuttal exhibit. They offered it in the cross-examination of Ms. Brophy.
All right, I'm not gonna rule on
And
that right now.
You know, and we may add a 403 argument to that as well.
Sure, well, go ahead and make the argument now so I can look at all this stuff at once.
Well, I suspect that the reason they want the jury to have that back in the room is that our client was not kind to Ms. Perez in her description of her. But more concerning is the fact that our client had referenced her as being Spanish, which I think has more to do with our client's generation, and maybe, in any event, that's why they want to have it. It has minimal probative value. It was explored extensively on cross-examination. It was explored in a different part of the case, not this part of the case, to the extent that it was going to be admitted, and we would have thought about it then. It's too late now.
All right, do you want to address either the 403 argument or the other argument?
Just the relevance and probative value, Your Honor, that it clearly goes to rebut something that Miss Brophy was talking about in her thoughts and feelings towards people who have been devastated by Mr. Brophy's death. And she clearly does, she testified to one thing and she's saying another on the jail call. So they're clearly relevant, but I think the jury should have that. They've heard it and they should be allowed to listen to it again.
All right, so just make sure I understand what we're doing now before we bring the jury back. Is it that, well, of course, the state, I'll have to say that I sustained the defense objection, and the state can rest if it's ready to rest. Then on the defense side of things, is the proposal to call Mr. Hersey, and then we'll probably excuse the jury for the rest of the day and take the proffer of Miss Lee. All right, let's do
Although
that.
he'll forever be known as Mr. Hearsay now because it's the kind
I
of
did
name
not
that-
mean to say
No,
that.
just for
and,
us, just for us.
Please don't tell him I did,
Okay.
although I'm sure he'll learn anyhow.
Are we doing our afternoon break now, or are we?
At this point, I think the jury's, do the attorneys want a break?
5 minutes to run to the bathroom.
All right.
But I can really
Well,
do it
let
in
me
5
ask the
minutes.
state, how much time for break do you want?
I don't think we need one.
Okay, let's
Still
take
5 is fine.
take 5 minutes to use the restroom. We'll go back on. At that point, you can have the jury seated before I.
Give you a bath. Yeah.
All right, please be seated. All right, for the jury, I did sustain the defense objection. Mr. Overstreet, any more witnesses for the state?
No, Your Honor, the state rests its rebuttal case.
All right, and then before, I want to give the jury just sort of an understanding of our time situation. I believe we're going to hear from one witness in the defense rebuttal case now, and that you'll be excused early today. Rest assured, we will be using the time, and I do think we're getting very close to completion. So I can't tell you exactly when, but I don't want you to think that because you're leaving early today, we're not moving the case along. We will be taking up things we need to take up outside your presence. So with that, I will turn to defense and ask if they're ready to call their first rebuttal witness.
We are, Your Honor. We'll call Richard Hersey.
Okay. And Mr. Percy, I know that you know where to go and what to do, so.
Thank you. And can I have you step into the box a little closer to the microphone, please? Thank you. Under the penalty of perjury, do you solemnly swear or affirm that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, then you may be seated and you may remove your mask.
Thank you.
And then, because we're being recorded, I'll ask you to please state and spell your first and last name.
Yes, my name is Richard Hersey, RICHARDHURSEY.
All right. And as I've told everyone, Mr. Hersey, there is water there if you want it, but whenever defense is ready.
Thank you, Your Honor. Good afternoon, Mr. Hersey.
Good afternoon.
How are you employed?
I'm self-employed as a private investigator.
Have you been working with us on this case?
I have been working on this case.
Did we ask you just recently to make arrangements with the Multnomah County Sheriff's Office to get some photographs of the interior of the two primary jails in Multnomah County?
Yes,
And were you able to do that?
I was able to do that.
What are those two jails?
One is at Inverness, and the other jail is downtown MCDC.
Right, right. I'd like to go through those photographs with you. And first, let me ask you, we're going to focus today on Inverness Jail because the testimony yesterday made that relevant. There was no testimony about MCDC, so we'll just go through the photographs with respect to Inverness.
Yes, ma'am.
Which of the dorms at Inverness Jail actually housed Ms. Crampton Brophy during the time she was incarcerated?
4, 6, 7, 13, and 18 were the dorms.
And were you able to get into, did the sheriff allow you access to each of those 5 dorms?
They did give me access to it. I was escorted at the time.
Okay, and they gave you sufficient access, you could take the photographs you wanted to take?
Yes, they did.
Okay. Did you go to some length to make sure you didn't photograph anybody else who was housed there to respect their privacy?
That is correct. They asked me not to photograph anybody who was an adult in custody.
All right, all right. Mr. Britton, would you pull up Defense Exhibit 410? Would you go to the 26th page of this exhibit? Mr. Hersey, about how many photographs did you take in all?
I took over 200 photographs.
Okay. And were you able to go through and curate that down to the set that best displayed how those dorms are laid
Yes,
out?
I was. Or I did, rather.
All right. So this is page 26. And which dorm is this?
This should be dorm 4.
And what are we seeing? Tell us about why you took that photograph.
This is an area that's right near the non-attorney phones. And so these would be recorded lines. The telephones are on the left, and on the far right would be a kiosk.
All right. Now, you described there being different kinds of telephones. How many different kinds of telephones? I'm not asking you about how many stanchions there are, but just there are different types of telephones, and I'd like you to describe those for us.
One type of telephone is the attorney telephone, and except for one dorm, those had some type of blue painted on the phone. The other phone is a regular inmate phone that is recorded. The attorney phone is not supposed to be recorded. And then there is a medical telephone for any emergencies or sick calls from the inmates.
All right, so what we're looking at here, if I understood you correctly, this is the bank of phones that is used for social visits and calls, and those are recorded calls?
That is correct.
All right. Can we go to page 28, Mr. Breton? Is this also in dorm 4?
This is also in dorm 4.
What are we looking at here?
So this is a common area in the foreground. This is also where the meals are served. And to the left would be the non-attorney phones. And then in the background is the sleeping areas for the dorm.
Where that half wall is?
Yes, that is correct.
That's where the bunk area starts. Are those all single beds? I said bunk, but I didn't mean to imply bunk beds. Are those all like one level beds?
I believe they are single beds.
All right. All right. How about page 31, Mr. Breton? Tell us about this one.
So this is a picture of the common area in the foreground. Then in the background will be the sleeping area. And in the background to the right appears to be the outdoor recreation area.
Okay. And we haven't yet seen the attorney phone in this dorm, is that correct?
No, we have not.
Okay. And then are you basically rotating around the room here?
Yes,
All right.
I am.
And page 33, Mr. Breton, 33. Why don't you just continue to walk us through these as we go page to page?
And this is primarily the common area, except in the very back to the left is the outdoor recreation area. And then to the right in the background is the sleeping area.
Now, is that a separate sleeping area?
That is.
Okay. And page 36?
In the foreground is the common area and the dining area. And then behind that in the background is the sleeping area. And then to the right of that area would be the station where the deputy is assigned. To the extreme right of that photograph, there's a brown, looks like it's slanted. That is the area where the showers start.
Okay, let's look at 47, Mr. Breton.
And 47 shows the area of the showers on the right-hand side.
And then 40?
This shows the showers on the left, and then behind the glass is actually toilets and sinks for the inmates.
And 42, Mr. Breton. Now what are we looking at?
Okay, in the background, behind the glass are the toilets and sinks. In the middle of the picture, in the foreground to the left is a telephone. That one is the medical phone. And then to the right of the cabinet area, the blue phone, that is the attorney phone.
And 51, please, Mr. Breton.
And 51 shows the area to the right of the attorney phone. The attorney phone is on the left-hand side of this photograph, and then the non-attorney phones are on the right side of the photograph.
Now, you had showed us a common area with some tables. Were you able to measure that or at least estimate the distance from that attorney phone in dorm 4 over to the tables?
I was able to take a preliminary measurement.
And about how far is it to the closest table?
It's about 11, it's a little bit less than 12 feet.
Okay. All right. And is there anything closer than those tables? That we saw that little station right next to the phone there.
Other than the medical phone, which was probably the closest.
Okay. And how, what's your best estimate of about how many people can be housed in that dorm at a time? If it was at maximum capacity, how many people would you expect might be housed in that particular unit that we've just looked at?
This would be just a guess based upon the numbers of the beds. I would probably guess 50 people, probably.
And did you see while you were there any sort of appliances that were there for common use, like a microwave or things that people might go up and use?
Yes,
in
there's
that
normally
common-
a microwave there.
All right. Do you remember about where that was in the room if we were going to go back to that photograph?
It is normally near the attorney phone and the medical phone.
Okay, Mr. Breton, why don't we just go back one? I think that would be to 40. Maybe 42.
And it looks like this one does not have a microwave in it.
All right, well, let's go to the next dorm then. Which one did you go to after dorm 4?
We went to, well, we can go to dorm 6.
Oh, okay. Mr. Britton, would you go to page 86? Now, is this dorm 6?
This is dorm 6.
And what kinds of telephones are we looking at over there on the wall?
These are the public or the non, or the recorded. These are the recorded lines where the inmates call family and friends.
Okay, and Mr. Britton, would you go to 63?
To the extreme left, that's almost cut off, is an attorney phone. And then to the right of that phone is a microwave. The microwave is sitting on a brown desk. And then to the right of that is a sink. In the background would be the sinks and the toilets for the inmates.
All right, and that's a microwave that appears to be out just for common use of everybody who's in the dorm?
That is correct.
Okay, and how far is that from that attorney phone that's almost out of the frame?
I'd say 5 feet or less.
All right, Mr. Britton, would you go to 64? We're looking at the same things from a different perspective there, correct?
That is correct.
Okay.
The attorney phone is on the left-hand side of the microwave.
And what's off to the left, almost out of the frame now, off behind that garbage can?
That is a cabinet. And it looks like it held cleaning supplies.
And where's the entrance into that bathroom area?
You know, I believe it is on the left side of the picture. There is a door with a handle.
And that blue plane that we can see there is actually a door.
I believe that is the access to the bathroom.
All right, would you, because you've got the pointer there, would you mind just pointing out, just make
Not at
sure
all.
we're talking about the same thing? All right, so all that traffic in and out of the bathroom would be right there by the attorney phone and the microwaves right there. Thank you. Mr. Brent, would you go to 94?
And this is a close-up picture of the attorney phone.
Was there generally one attorney phone in each dorm?
That is correct.
87, please, Mr. Brenton. All right, which dorm did you go to after that?
This should be dorm 7.
Okay, how about page 117, Mr. Breton? Thank you. What are we looking at here?
One second. This is dorm 7. There is a 7 above the doorway and a 7 on the wall.
All right, how about 119, page 119, Mr. Breton?
In the background behind the glass are toilets and sinks. and there is a sink on in the foreground part of that, and there's a microwave on a table to the right of that sink.
Okay, and is that blue door that we can see there, is that the way into the bathroom?
I don't know the answer to that because I'm not sure if there's a door on the other side, but I believe that is the door to the bathroom.
And is that 120, Mr. Britton? Okay, 127 then, please.
Oh, no, this is 120 now.
This is 120, so let's go to 127.
That's a close-up of the attorney phone.
All right. Which dorm did you go to after that?
I'm actually going in numerical order, so this would be dorm 13 next.
Okay. Tell us about this photo.
This dorm was occupied, and I was able to shoot a limited distance with the limited angles. To the left is the sleeping area, and I'm actually standing in the common area shooting that photograph. And in the background, straight ahead of me, are the non-attorney kiosk.
All right, is this a medical unit?
No, this is not the medical unit.
Page 130, please, Mr. Britton.
I'm actually standing in the common area. There's a table in the foreground in front of me here, and then there are kiosks for the non-attorney phones straight ahead. To the right of those kiosks, there's 4 kiosks. To the right of that is a medical phone, and then to the right of that medical phone is the attorney phone.
And are all of these dorms approximately the same size? Would you expect the capacity to be, the maximum capacity, if full, to be about the same?
They would be close. The first 3 are just about the same. They're essentially the same. This one was a little bit different, had more of a rectangular construction to it.
Mr. Britton, would you go to 140?
This is a close-up of the attorney phone on the right, and then the phone on the left is actually the medical phone.
All right, and 133, please, Mr. Britton.
This shows in the foreground, common area, that there's a table there. And then in the far left side of that, there's a kiosk. And to the right of that, there's the medical phone. And to the right of that would be the attorney phone. And to the right of that area, there is a whiteboard and a sleeping area just to the right of that whiteboard.
And what's your best recollection of about how long that whiteboard is? What's the distance between that attorney phone and that corner where the sleeping area starts?
It's about 9 feet.
Mr. Britton, is that 133? Have we gone to that yet?
That's 133.
Okay. All right, so the last dorm was dorm 18, you said?
That is correct.
All right, can we have page 185, Mr. Britton?
And this is the medical dorm.
Okay,
And I'm standing in a common area, and the common area is in the foreground here, where those tables are. In the background, you could see cell doors, is how I would describe those. And this is the dorm that has individual cells. It's called a dorm, but it doesn't have a dormitory type of feel to it because every inmate in this dorm has its own cell behind a locked door.
all right. So if the description that had been given was that the room involved the beds that were behind those half walls, presumably it would not have been in this unit?
I'm sorry, would you repeat
If
that,
the
please?
description that was given during testimony was that this occurred in the room that had the half walls with the individual beds, this would not be the dorm that you would think?
This would not be the dorm.
Okay, all right, well, let's go through these. There are only about 2 more, I think, anyway. 182,
I'm again standing in the common area. The prior picture showed me shooting to the left. Now I'm shooting to the right. On the left-hand side, there's a brown cabinet, and then there is the attorney phone um, against that wall, and then cell 9 is right next to the attorney phone.
Okay, and then the last one is 202, Mr. Britton.
This is a close-up of the attorney phone.
Okay, were you able to determine what those doors on either side are? There are
Excuse me.
doors on either side of that phone. Were you able to determine what those doors go to?
Well, the door on the right-hand side is actually a cell door, number 9. I'm unsure what the door to the left is.
Okay, and I can see that 9 now. All right. Good. All right. Well, thank you for doing that. I appreciate it. No further
Thank you.
questions.
All right, cross-examination?
No.
Okay, I can step down.
Thank you, Your Honor.
All right, and for the jury, that concludes your portion today. So we'll excuse you and have you come back and be ready to go at 9 o'clock tomorrow.
Okay, and Judge, you go off record second briefly.
Sure.
Okay, I will go off record and I will mute the lawyer.
So Ms. Weinmiller, you were out when we brought up an issue, and I'm just asking for an estimate. If, and I'm not saying they will, but if all the defense rebuttal witnesses were permitted to testify, where do you think we would get through tomorrow? What we're trying to figure out is whether or not we'll be taking up the jury instructions tomorrow.
Well, we're hoping to. I sent an email to council last night indicating that would be hoping to have time left tomorrow to get to that. But
Okay.
I have confessed before to being overly optimistic.
No,
and that remains true.
I understand that. So I think that we can expect that we might go over instructions tomorrow at some point.
Okay, we'll be prepared for that.
Okay, all right. And I will tell the sides, I will be working off the combined instructions. I have not looked at them. So to the extent there are disagreements, there are times where one side asks for an instruction and the other side isn't really objecting. They just didn't ask for it for whatever reason. But to the extent you're able to figure out which ones you object to or have differences of opinion on, that will make things go more quickly. All right, so with that in mind, just to repeat, what we're doing right now is going to take a proffer of Miss Lee's testimony. I'm not going to rule right now. I want to go and look at a few things with regards to ruling on her. And I already asked, but I apologize. Is it Mr. Jeffers?
Yes, Aaron, Aaron.
And will Mr. Jeffers be available for a proffer tomorrow?
Yes, we're planning to have Ms. Maddox come in first. She also has had a death in the family, so
Oh,
we want to make sure
wow,
we don't
okay.
hold her up at all.
Sure,
Then put him in, he's driving up from Salem, so it'd be
okay.
nice to get him on second, and then,
All right.
I don't remember the order for the rest. I can look it up.
That's okay. I don't need to know right now. I'm just trying to, in my own mind, think things through a little. All right, so Miss Lee, now we can have you come up, and we're going to have you step into the jury box, get as close to the microphone as you can, but don't sit just yet, and my clerk will give you a note.
Okay, I'll ask you to please raise your right hand. Under the penalty of perjury, do you solemnly swear or affirm that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, then you may be seated and you may remove your mask. And then because we're being recorded, I'll ask you to please state and spell your first and last name.
Rosalind Lee, Rosalind Lee.
All right, and Miss Lee, there is water there if you want it,
Thank you.
and then defense when you're ready.
Thank you, Your Honor. Ms. Lee, you are an attorney.
Yes.
What is the nature of your practice?
I am a solo private practitioner, and the vast majority of my work, over 95%, is criminal defense.
All right. Do you practice both in federal and state courts?
Yes.
Is most of your work in federal court?
Currently it is, yes.
All right. In that capacity, have you had, or let me ask you this way. How many years have you been working with the federal guidelines?
We learned about them in law school, but other than the first 2 years of my career when I was at the public defender's office in San Francisco, I've always worked with the sentencing guidelines.
All right. And tell us just a little bit more about your background. Where'd you go to law school?
I went to Howard University in DC,
All right. And undergraduate?
UC Santa Cruz,
All right. When did you move to Oregon?
in 2005.
Okay, so you were practicing for a short period of time
About
in
9 years.
California?
Yes, I graduated from law school in 1996, and then I returned to San Francisco, which is where I'm from, and I worked for the public defender's office for 2 years, and then I started a private practice in about 1998.
All right. And so 2006 is the year that you moved to Oregon?
2005, yes.
Okay. So you've been working with the Oregon guidelines since 2006, but did you begin a federal practice while you were still in California?
Yes. Yes, as soon as I left the public defender's office, I started working on federal cases as well.
Let me focus you specifically on federal practice, and there are a couple of areas I want to ask you about. First of all, let's talk about the guidelines and how you would, if you had a prospective client come into you or a new client and you were trying to figure out what that client's exposure was, and you knew that the client had 4 prior convictions arising from 2 separate incidents, all of which involved felonies, crimes of dishonesty or fraud convictions. And the person was now under investigation for a new set of fraud activities that cumulatively, maybe multiple incidents, but the aggregate prospective loss was perhaps in excess of 500,000. How would you go about assessing what that person's exposure was?
The United States sentencing guidelines are a set of rules about how we calculate what someone's exposure is. And the rules assign a series of points to the severity of a crime, and the points go up and down depending on, for example, the amount of the loss in a fraud case, and also the person's role in the offense, whether or not they were on supervision at the time. So those points can go up and down. Then we also calculate, using the same guidelines, the person's criminal history category, and that is based on what their prior convictions were, how old they were, and what their punishment was. And then there's a grid at the back of the guideline book, and the horizontal axis is the crime seriousness, and the vertical axis is the criminal history category. And then you just find your client's guideline range, and that's where you can really say to a client, this is about what you're looking at. This is where the court would start their analysis and a punishment for you.
All right. Which of those axes is typically a little bit easier to figure out than the other?
Well, it depends. I think that in particularly if a client's coming to you as a target, when they don't have the charges, you're having to guess a little more about the offense conduct. And if your client has an accurate memory as to their criminal history, then that's a little easier to calculate.
All right, so if the client came in and said, I have 4 prior convictions, they arose from 2 separate incidents and 2 separate cases, and I received a joint sentence, a combined sentence of 4 years, what would that tell you about where the person's likely to fall on the criminal history scale?
As a general rule, if you are sentenced to a prison term for more than a year, you're assigned 3 points for that conviction. If the 2 sentences arose out of different cases and different, like say, different case numbers and different indictments, then they would each count separately for 3 points each. So you would get 6 points in terms of your criminal history category. If the current case was the current allegations, if those crimes were committed while you were on supervision or release on one of those cases, you get another 2 points added to that. So that's 6 to 8 points. And that's a criminal history category 3. So it kind of puts you right in the middle of the vertical axis.
Okay, so if you've got 8 points, you're in criminal history category 3.
Yes.
All right. Now, the client says, I am not sure exactly what the dollar amount is, but I'm pretty confident it's more than $500,000. And it's something that would be charged as a fraud offense or a set of fraud offenses. How do you go about assessing that other axis of the grid?
Depending on, generally any kind of fraud or theft crime involves the same guideline rule, same sentencing guideline is how we call it. And there's a base offense level of either 6 or 7 points, depending on what the statutory maximum of the crime is. So if it's a wire fraud is a 20-year statutory maximum, so you start out with 7 points, and then there's a chart where you add points depending on the loss, and so there's a range where you add a certain number of points if their loss is more than $550,000, and that is, I'm sorry, I have notes. I think that loss should be, I think it's 14. Between $250,000 and $550,000 is 12 points, and more than $550,000 is 14 points.
All right, so you'd want to ascertain exactly where that dollar loss was going to fall. Is there a straightforward rule about how loss is calculated, or are there varying definitions for loss in the federal system?
Generally, with fraud, I think it depends on the crime, but generally, the loss is the actual dollar amount that was taken as a result of the fraud.
Okay. And if there were frauds underway but not completed, is there a concept of intended loss that you also have to look at in making this analysis?
Yes, right. If there's an ongoing fraud, even if the complete fraud was the theft wasn't completed, the potential loss is also something that you can take into account and calculate in the guideline range.
Okay. Is that the end of the analysis for that axis?
No.
What's the next step?
You consider the person's role in the offense, and that can change if someone is an organizer or manager of an offense, then they can get additional points. If they played a minor role in the offense, they can get points off. An example in fraud cases is that if you were involved in a fraud but you didn't make any money off of it, then you can get points off. But if you made all the money, you aren't going to get that kind of that money off, or those points off. You can also get additional points for obstructing justice. So if you obstruct an investigation in any way, then the government can seek an additional 2 points if they find that you lied or tried to hide your criminal conduct. That you can also get additional points if you committed the offense while you're on release.
Okay, so on that axis as well, the fact that this is committed while you're on supervision could cause a further consequence?
Yes.
Okay. And what about circumstances or characteristics of victims?
Yes.
If, for instance, the population that was targeted by your offense was an elderly population, what would that do?
You can get additional points for having a vulnerable victim. That's an additional 2 points. You can also have additional points if you cause substantial financial hardship to the victim. So that's also another 2 points. So you can continue to add points to the offense level depending on the characteristics of the offense, your role in the offense, and then the nature of the victim.
All right. And in fraud offenses, is there also a concept and a guideline that relates to sophisticated means?
Yes.
How does that work?
If it's, if the court finds or the government can prove that the person used sophisticated means to effect the fraud, so something other than just check kiting. You know, check kiting is a fairly simple fraud, but if you use more sophisticated means in terms of running a business or running some sort of insurance scam or doing some sort of sophisticated billing scam, then I think the government would take more of a harder look at and to see if they could seek that guideline enhancement as well.
All right. So if you're concerned that this is over that 550,000 threshold, and that some of these other enhancements, is that the correct term?
Yes.
Might be added to the sentence. What could you be looking at this point for somebody who has 8 points and is in a criminal history category 4?
I think you're looking at the guidelines start at conservatively at 63 to 78 months, about there.
All right. So what are the things that a client can do to mitigate that harm? If you can't back up in time and undo the conduct that led them to be targeted in this investigation, but you see the freight train coming down the road, there's no indictment that's been lodged yet, and you are trying to help this client strategize about what best to do to manage this looming disaster. What are the options available to you? What are the next steps?
A really common option, and particularly in the federal system, is that people can cooperate with the government's investigation. If you've received a target letter and you've reached out to an attorney, that's certainly always an option that people talk about, is that reaching out to the prosecutor and finding out if your client can provide substantial assistance to the government, either pre-indictment or even after an indictment. And there are benefits built into the federal system for a defendant in both of those circumstances. And so cooperation is something that comes up very frequently.
When you say frequently, in the course of your practice, could you just hazard a guess as to what percentage of your federal cases that's at least been a consideration, even if it hasn't materialized?
Oh, I think we talk about it in every case. It's always part of the discussion. Not everybody cooperates, but certainly, and it's certainly changed from when I started practicing 25 years ago. It's now not only built into the sentencing guidelines and the United States Code, but it's become very common and almost pro forma. But it's absolutely part of the discussion that you have with the client as to one of their options.
And would you consider it malpractice not to have that discussion with the client at the front end?
Yes, you have to tell them the options. It's to me, it's up there with it's a discussion that you have right up there with going to trial and all of those other decisions. It's a very, very important decision that you have to discuss with your client at length.
All right. And is that because it can have such consequence to the outcome?
Yes, yes, it can make a huge difference.
Short of being acquitted at trial, is there anything else that can make that significant a difference in the federal system?
No, I don't think so. There's a lot of opportunity and a lot of discretion on the part of the United States attorneys, particularly in a pre-indictment posture where the government has a lot of discretion about how to treat your client if someone is cooperating.
All right. That's what I was going to ask you about next. So there are two different scenarios. One is the one that we've been discussing where the client comes in and says, I see this freight train coming, but I've gotten a target letter. There is no indictment lodged at this point. Maybe it would be helpful if you just defined what a target letter is. I think everybody knows, but.
So oftentimes, if you haven't been arrested and accused of a crime, the federal government is nice enough to send you a letter, and they tell you that you are a target of a federal investigation. They recommend or suggest to talk to an attorney, and they give you the number of the federal public defender's office, if you can't afford one, to give you the opportunity to get legal advice right out of the gate. And so I will get, someone will contact me and say, I've gotten one of these letters. They're terrified. And then they come and talk to me, and we start talking about about options.
And are those letters sent in every type of case, or are there particular types of cases that the government tends to send out those target letters?
In my experience, they tend to be in cases involving fraud, where the government doesn't see an imminent public safety threat. So in a case where if you get stopped with a bunch of guns, they're probably going to arrest you on the spot. But in a case where the government feels like the person's not going to leave, they're not that the government's fine with taking their time. And also if the government feels like that this person has information that could be valuable.
All right. So with the target letter, let's stay in the scenario that we've been discussing so far. What typically happens, or at least what's your practice once the client comes in with the target letter, you have this conversation, you lay out the options, and the client is frightened enough that their response is, gosh, we better explore cooperation. What do we do next? What's your advice at that point, or what do you tell them you propose to do?
The next thing I usually do is I call the U.S. attorney. I talk to my client and I get a sense from my client whether or not they would like me to have that conversation with the U.S. attorney. And I'll call the U.S. attorney and find out what the case is about. And we start discussing the case and what information can they share with me pre-indictment. And inevitably, the U.S. attorney will say, would your client like to come in? It's almost the first conversation with the U.S. attorney is that your client's invited to come in and have a conversation with the government.
Okay, and are they generally fairly forthcoming? Do they give you accurate information about what the investigation's about? Maybe not the entire scope of the investigation, but do they accurately lay out what they are thinking about doing and what they know about your client and therefore hope your client can do for them?
Generally, yes. Sometimes they'll provide discovery before pre-indictment or during this process to give you a sense of the evidence against your client. Sometimes they'll invite you in to sit down with them and they will give you kind of a showing of what they think their case is about, and they will give you a fair amount. They won't tell you everything, but they will give you I think, a fairly clear view of what they know and what information that they think that your client can provide to them.
All right. Now, you talked about the prosecutor having more, in the federal system, the prosecutors have more discretion if the case has not yet been indicted. So let's talk about this other scenario in which the client maybe has gotten a target letter and ignored it, or something has happened to cause the case to progress to the point that there's now a filed case, there's actually a prosecution underway. Do you still have the same kind of conversation with the client in that scenario?
Yes, always.
Right. And does it still seem to you, or is what you represent to the client, that the possibilities that might arise from cooperation could be beneficial enough that they are worth exploring or perhaps worth pursuing?
Yes, I mean it's still the same. It's the same analysis. Is that the government is still always open and available to have a client cooperate or to have anybody come in and cooperate, even if the case has been charged. It's something that's still to the benefit of the client to consider it because there is a potential benefit out there.
What do you do if a client says, gosh, I just don't think I know anything. I feel like a little fish. They know so much and they've got so much going on. Why would they want to talk to me?
I find that the government is willing to talk to kind of anybody. I mean, they're not necessarily. There's two dynamics there. One is that they're interested in talking to the big fish because federal prosecutions and state prosecutions also start with the small fish and they work their way up. So they are more than happy to talk to the small fish. Also, that in my experience here, particularly, that the government would like to give people a benefit. To come in and talk and say, sure, we'll talk and listen to you, and what you know is what you know. They don't expect you to know everything.
Okay, but is the importance, the magnitude of the information that the client can offer to the government, is there a scaled response that reflects how significant the information the client offers?
So I stopped hearing you. Can you repeat that? I'm so sorry because of the mask.
So the government is willing to consider even information that at least the client might think is relatively insignificant. You explained that, but is the government's response, and by that I mean the benefit that they ultimately are willing to consider bestowing on the client, does that reflect the ultimate significance of the information to the government? I mean, is there's kind of a scaled response that reflects?
Yes, absolutely. So if you come in and you're just assisting because you're trying to assist and you don't know anything, but if you're able to provide new information to the government and things that they didn't know or corroborate things that they already know, you would certainly get a better benefit, a larger benefit if you do that. So certainly the quality and the quality of the information in terms of things they don't know is certainly of greater value to the government, and so you'll get a greater benefit for that.
So in the scenario where the case has already been filed, there's ongoing prosecution, how is a benefit actually then bestowed on the client? What are the ways in which that can play out so that the client does see some benefit from this?
In terms, so I'm sorry, post-indictment?
Yes, post-indictment.
It can fashion in a lot of ways. The government could dismiss the case and send the client to state court. And that if it's a circumstance where the client's exposure is less in state court, that's one option that can happen. The court can, the government can prosecute a less serious offense. That's within their discretion in the U.S. Attorney's Manual.
Just refile a new charge.
They could
to
file
start
a new
over?
charge. Correct. They would, after an indictment, they just file an information to a lesser charge as a benefit. They can also, once you get to sentencing and the guideline range has been calculated, the government can file seek a reduction in the guideline range under under Chapter 5 of the guidelines. And that's also a very common way for the government to seek a reduction in a serious federal criminal case.
And is there a standard range that the government is working with for that kind of reduction in its sentencing?
Yes, I do think it's office specific, but it's generally 3, 4, or 5 points off in the guideline range, depending on the effectiveness of your assistance. Sometimes they do huge ones, 10 points, depending on the value of the information.
All
And,
right.
and that is very much at the discretion of the government.
Okay, so apply that standard range, though, to this scenario that we're talking about. You said, I think, 57 to 63 months. If that were reduced by, let's take the middle of the range, 4 levels, and how big a difference would that make in that grid block that the person falls into?
So if I had a criminal history category 3 and
I think you were in 4, weren't you?
or
were you
4.
3?
Sorry, I
don't
calculated
remember.
calculated it as a 3,
Okay,
and I
you're probably
apologize.
right.
I didn't bring my guideline book
Okay.
with me, so I apologize. But I think that gets her down to about 36 months as the low end of the guideline range, and that's a drop from 63 months.
Okay.
So it's a significant drop.
Okay. Now, there are 2 other scenarios that I want to talk with you about. One is, now let's say the case has progressed to the point that the person's already been sentenced. They've gotten this 4-year sentence. For purposes of this discussion, just assume that that was not a sentence that was brought about by some sort of cooperation. That was just a sentence that was imposed. But the person then says, oh my gosh, I can't do 4 years. I need to come up with something, or information comes to them that they think might be of interest to the government. How is that handled? It's already not a completed, already served sentence, but an imposed sentence.
The government, under the federal rules of criminal procedure, the government can file, we call them a Rule 35 motion, and that is where only the government can ask the court to allow for a resentencing, and for that exact reason, if someone has cooperated, and then they can ask the court for a lesser sentence. And that's something that happens also. You see those less often, but certainly if someone, it's a great way for the government to keep someone's cooperation as secret as possible. Down the road, they get a Rule 35 motion.
Okay. There has been in the federal system for some time now something called compassionate release, correct?
Yes.
Has that become quite a bit more frequently utilized during the last couple of years due to the pandemic?
Yes, absolutely.
Does that also provide some opportunities?
Yes. Yeah, so the government can agree or disagree for a compassionate release. There's a fair amount of discretion in whether or not someone qualifies, whether or not there are kind of the appropriate circumstances, because there's a catch-all for compassionate release, and so there's a fair amount of discretion.
If the government wanted to do that, could the government grant, or of course, the judge ultimately has to grant it, but could the prosecutors in the federal system recommend and go along with compassionate release and never say a word about the fact that part of their motivation was that this person had cooperated?
Absolutely. Absolutely. The existence of cooperation is something that's kept very much out of the public record.
And if a person testifies, of course, it has to come to light.
Correct.
There are rules that require disclosure,
Yes.
full disclosure.
Yes.
Right. But if the person is providing information in a non-testimonial capacity, is it standard procedure to go to great lengths to keep that secret?
Absolutely. And most federal cases don't go to trial. I think there's like 97% of federal cases resolved before trial. And if someone is cooperating, there's a whole series of rules and procedures that keep the fact that someone is cooperating out of the public record intentionally. The rules are set that intentionally.
Now let's go back to that initial scenario. Let's say there's no filed case. The prosecutor at this point hasn't made any commitments about what's going to happen or whether the case is going to go forward. Person gets a target letter, or they even just suspect for other reasons that they're about to get a target letter. They're the subject of an ongoing investigation, and they're savvy enough to seek out counsel and start pursuing these options on their own. What kind of discretion does the federal prosecutor have in that instance and specifically to reward cooperation?
The U.S. Attorney's Manual, which is now called the Justice Manual, is a document that guides the prosecutorial choices and discretion for United States attorneys around the country. And there is a particular guideline or standard that talks about declining to prosecute somebody. And it says specifically that just because a federal prosecutor has the evidence that someone has committed a federal offense, it doesn't mean that that's not the end of the story for a federal prosecutor in choosing to prosecute. And and there are several reasons why a federal prosecutor would decline. One is that there's no clear federal interest. One is that there's a jurisdiction that can handle it, like a state court. And then there's kind of this more of amorphous that there's not this federal interest to do so. And it's that kind of catch-all. When you read the guideline, it really gives the federal prosecutors wide latitude in declining to prosecute certain cases. And so they have the authority within those guidelines. And it's important that the U.S. Attorney's Manual doesn't create a right in a criminal defendant. It's just guidelines. So you can't require the government to do it. It's just within their discretion to do it, and they do.
And in that scenario, then the prosecutor wouldn't have any obligation to take that to a judge for approval or to file some sort of document that ultimately would be in the court record.
No.
That would all just be inter-office.
Right, it's all inter-office.
Okay. All right. Do you think? That's for this though. Yeah. Yes. To the extent that you know, in the federal bar, are you familiar with the reputation, the professional reputation, and the competence of now Judge Celia House? Are you familiar with her reputation?
Yes, when she was a lawyer.
Yes, when she was a practicing federal practitioner. How would you describe the esteem or the reputation the esteem she was held in and the reputation she had amongst the criminal defense bar, or the criminal bar, federal bar?
She had a reputation of being thorough and hardworking and a strong advocate for her clients.
All right. I think that's it. Thank you, Your Honor.
All right, cross-examination.
Hi, good afternoon. I hopefully just have a few questions for you, but hopefully that won't morph into more. I just wanted to start off, do you know Andrea Jacobs?
No.
Okay. So you haven't done any work on her potential exposure on a potential investigation or anything like that?
I'm sorry, I don't know her personally,
Okay.
but I am familiar with public records regarding her criminal history, yes.
Okay, and that's what you were talking about. You were kind of working off her real criminal history.
I'm sorry?
You were working off of her real criminal history.
Yes.
Okay, fair enough. And but what I'm getting at is, did you look at any active investigation? Were you provided with any information about an active investigation And did you do a workup on what her potential exposure would be on that active investigation?
I am familiar with that she is subject to a current investigation by the Oregon Department of Justice regarding Medicare fraud. And my recollection is that the loss amount in that case was about $230,000. And so she would fall, I did do some calculations as to that. The base offense level, if they charged her with wire fraud, which is just fraud using emails and the phones, is that her base offense level will be 7, and you get an additional 12 points for the loss. And well, maybe 10. It's a little hard to say, 10 or 12 points for the loss. And then depending on whether or not there'd be obstruction of justice, or if the timing for her, if she was committing those offenses when she was on release for her other federal cases, all of those things, I couldn't know from the documents that I have, from the public documents.
Okay.
And but anyway, so her exposure, I think, would be close to 63, just the low end would be 63 months under the guidelines, I
Okay.
believe. But I don't have, that's my best estimate.
Depending on some other factors.
Other factors, and that I don't have any reports. I just have that. The only thing I've reviewed is that letter.
Sure. Have you somehow attempted to relay that information to Ms. Jacobs?
No.
And do you know if Ms. Jacobs received one of these target letters that you talked about?
I believe she received a target letter in 2017 for her 2018 federal prosecution.
Okay. And do you know if she cooperated in that case?
I don't.
On that issue of cooperation, have you ever advised a client to cooperate without getting any sort of benefit?
Even though they're not getting a benefit?
Yeah. To offer information to the federal government or the state government, doesn't matter, and not ask for an exchange?
Yes.
Okay. And if somebody resolves their case without cooperating, do you put that on the record?
No.
You wouldn't stand up in court and say this person is not cooperating?
There's a guideline that says you can't hold it against somebody for not cooperating.
Right.
But no, it's not something, particularly in the District of Oregon, the issue of cooperation is kept out of the public record, and it's not discussed in
Right.
open court.
And so in general, unless somebody blurts something out, which I think has happened on occasion about cooperation, in general, when somebody takes a plea deal and that recording in state court, we call it an FTR. I don't know what they call it in federal court. That recording, you wouldn't hear anything, or there's no paperwork that says, yes, this person's cooperating, or no, this person's not cooperating. It's in the public record.
In the federal system, when you plead guilty, you have a plea agreement, which is in the form of a letter, and you have a plea petition. And if there is a cooperation agreement, which is what you have to enter into if you're going to get a benefit, that is something that's physically handed to the judge, so the court can see it. But it's not part of PACER, which is our Odyssey,
Right.
similar to Odyssey.
Right.
So that's not part of the public record. When you go in federal court, the sentencings are always separate from the change of plea. And when you go to sentencing, there is another letter that the government hands the court to say this person has cooperated, and it gets handed back to them. So there's and they don't usually say it. I mean, it's really not part of the actual transcript. We have court reporters still in federal court, and so it's generally not part of the transcript as a matter of practice.
Okay. And even if there wasn't a cooperation, so there isn't that letter passing back and forth, nobody would know, just looking at the public record, whether somebody cooperated or not cooperated.
Correct.
Okay. I will fully admit I do not understand the federal guidelines. They seem to be much more complicated than the state guidelines. Is that accurate? Maybe not for somebody who's seen them or practiced with them for a long time, but
sometimes I find the state ones to be a little difficult too. But yeah, they're complicated.
okay. Do you find that when you are talking to your clients about that, does it take a while to kind of educate them on what the guidelines are, where they fit, where they fall, and why?
I mean, not particularly.
Okay, I mean, I guess, do you have clients ever come to you that fully understand the guidelines without you having to walk them through it?
No, I mean, if a client has been in the system,
Sure.
has a prior, then they probably understand the system, or they know somebody who's been accused of a crime.
Right.
But no, they don't. The federal sentencing guidelines are not something that people know.
Right. When you talk about cooperation in the federal side, it's maybe different on the state side. When you say in every case, or almost, maybe it is in every case, I don't want to put words in your mouth, but that cooperation is on the table. Is that just cooperation on other people's cases, or does that include cooperation on their own case?
Both.
Okay.
I mean, so you can cooperate. I don't think there's a distinction. I mean, I don't think there's a distinction.
Okay. But in at least federally, if somebody's offered cooperation, it doesn't necessarily, let's say they do cooperate, it doesn't necessarily mean they're providing information on other people.
Yeah, I mean, they are. They're, if, what happen,
I'm
what
sorry,
happens is,
I'm going to rephrase the question. I think I don't want you to ask a bad question. It doesn't necessarily mean that they're cooperating on other cases. They could be cooperating within their own case.
correct.
Okay. I think I get it. I think that's all I have for you. Thank you.
Thank you.
Any redirect?
A few, Your Honor. So with respect to this last scenario, somebody's cooperating within their own case. What does that look like?
If someone is involved in like a big fraud with other people, or drug dealing, such an easy example, that if they're cooperating within their own case, then what that means is that they are identifying other participants, the roles that they played, they're identifying new people. They may be talking about that the scope is much bigger than the government realized, or they're identifying certain people for the government, that the government, they don't know who they are. They've got a photograph of somebody they'll identify. So they're providing additional information.
So the cooperation is always against other people, but it can be other people within the organization that's led to the indictment that also caught them up. Or it can be about entirely unrelated criminal activity by other people, or something in between.
Yes.
Now, with respect to the question about moving forward without an agreement, I think that that's something that's unique to the federal system. Would you describe that as a difference between state court practice and federal court practice?
I'm sorry, did you say moving forward without a plea agreement?
No. Moving forward with cooperation without an agreement about what the plea agreement will ultimately hold, what the outcome of the cooperation will be.
Yes, it's fairly it's fairly predictable.
Okay, so in the federal system, is it relatively routine to have a prosecutor say to you, yes, I'd like to talk with your client. I can't tell you at this point what I'm going to do. I need to hear their information first. And are clients sometimes apprehensive about that prospect of going in and having that conversation without knowing what the benefit will be?
Yes.
What do you say? What do you tell the client?
I tell the client is that there's a benefit. Is that if you go and you sit down with them, there will be a benefit. We didn't talk about this, but there's a proffer agreement that gives your client some protection about the use of their statements against them. So there's this, there's some protection about they're not just waiving their Fifth Amendment privilege completely. And so there is a certain amount of protection, and that, in my experience, that the government provides a benefit. You get a benefit.
So when you're at that initial stage, you're going in for the proffer, the government sends you, the evening before, whatever, provides you with this proffer letter and says, we agree that the parameters of this conversation will be X, Y, and Z. Do those parameters typically include anything that has to do with the benefit the client will ultimately achieve?
No, they don't tell you exactly what no.
And at what point in the process then do you have that conversation with the prosecutor? So you take this leap of faith, or tell your client to take this leap of faith. You sit down, have the conversation with or without the proffer agreement, and then what are the next steps? When is it that your client usually learns, presumably through you, what that benefit will be? How does that part of the process play out?
When you start negotiating the resolution and the plea agreement with the government, and you always start with a guideline range, and then you start talking about are you going to jointly recommend a sentence? Are they going to recommend a floor? You know, when you're starting to negotiate that, that's when the government will tell you and give you a strong sense of how many points that they're going to ask the court to reduce it by. So you have a sense when you're negotiating the ultimate resolution.
Okay, and these two other scenarios that we talked about, somebody who's already been sentenced, or what I would take to be the more frequent scenario where a person's gotten a target letter, but there is no indictment lodged yet. Do the proffers often go forward in those scenarios as well? Is the proffer kind of standard across any of those three?
In my experience, it is, yes. There's a proffer agreement, and then you sit down and to share with the government what information your client has.
Okay, so either in a pre-indictment or a post-sentencing scenario, you could also have the situation where you're saying to the client, you've got something of benefit to the government, and my advice to you is that you have some confidence that there will be a benefit on down the road, but I cannot tell you what that will be.
Yes.
All right, I think that's all I have. Thank you.
Thank you.
All right, you can step down. And just so everyone is clear on sort of the order of how we'll do this, I'll rule on Ms. Lee's testimony first thing tomorrow morning when I've had a chance to look at a few things. And then I believe defense will be ready to go into either Ms. Lee's or other people's testimony. It's a little unclear to me when we will take up the testimony of I've already forgotten the name. I think it's Mr. Jeffers. So we'll deal with that.
Can we ask the court, I don't remember which exhibit it is, but one of the exhibits that we introduced as we were litigating whether Ms. Jacobs' testimony would be allowed, and if so, what the parameters would be. We offered the court the government sentencing memo in her case, and that sentencing memo sets out in detail the guideline calculation for her before she had this criminal history in a fraud case with a loss amount of like $250,000. I think that it's inconceivable with a lawyer as competent as Celia House, because it really is malpractice not to do this. It's inconceivable that her answer could have been truthful, that she did not have any idea what penalty could follow, because even if she gave herself the benefit of the better amount that was set out in that sentencing memo, she would know how those guidelines work, at least generally, and would know that she had exposure. At least in that case, it was 48 months. But I think the government sentencing memo in that case that we offered was 402.
Do we have a 402? Yeah. Okay, I now have 402.
And I think I was looking at was it page 4, where the government lays out in detail exactly how those guidelines would break in her case.
So let me make sure I understand what's happening. You are offering to admit 402. It was admitted for purposes of the motion.
I think we may offer to admit it tomorrow. What I'm saying to Your Honor is that as you're deciding whether this additional testimony would be allowed, I think it's important to keep in mind that when this witness said she had no idea, she did not know what potential exposure she had, it's just demonstrably false, because she had gone through this exercise, I presume, both with her lawyer and then later with the government, where they used the federal fraud guidelines to explain to her what was going to happen to her in that case. The only difference between that case and this case would be the new criminal history, and then combine that with the fact that the loss amounts are greater. but she had to know, at the very least, that she would be exposed to penalties similar to the penalties that were imposed in her earlier case.
Okay, so you're asking me to consider this as part of the analysis as to whether or not I would allow the testimony of Ms. Lee. That's what you're
Yes.
asking for right
Yes, Your
now. Okay. Do you want to say something, Mr. Overstreet?
Yes, just also, when you're considering your, whether you're gonna allow this testimony, I think it's Defense Exhibit 400, it's that DOJ letter we keep talking about.
Right.
I think that would also be important for Your Honor to take a look at, because I don't believe it references anything about soliciting any cooperation.
Right.
So I'd
Okay.
ask that you take a look at that. And then I just want to note, Your Honor, that what defense is asking I think,
I don't need
regarding the sentencing memo,
Thanks.
is to assume that one, Ms. Jacobs ever read it, which they didn't ask her about, so there's no evidence of, and that she had considered that letter when she received the DOJ letter just a couple of weeks ago, because that's what would have to, you'd have to make that connection for her to have this be a lie. And I just don't, what we're obviously arguing is that this is way too attenuated. It's not really direct extrinsic evidence that suggests that she's lying, because there's no proof that she actually would have known any of these things.
All right, and then the one other thing I hadn't ruled on, because I just want to make sure I'm remembering everything, but the other thing for me to rule on is admission or exclusion of the voicemail, which is the state's Exhibit 116. So I also will rule on that tomorrow.
And Your Honor, Ms. Weinmiller points out that we would ask the court also to look at 403, which is the second superseding plea offer. And again, you lose your license if you didn't review that plea offer with a client before she entered the plea.
Client has to sign it.
All right,
Pardon me?
and subject to
Client has
the
sign
same
it.
type of
Oh, and the
state.
client has to sign it. I forgot about that. That's true. And she has to say that she's read it and she understands it.
All right, and 403 is the plea agreement related to the 2018 and 2020 cases, correct?
That's correct, Your Honor.
And I'm assuming the same sort of state objection exists for that.
My objection to what, Your Honor?
So defense wants me to consider what was admitted for purposes of the motion as defendant exhibit 403, which is the plea agreement that was reached with Ms. Jacobs in the 2018 and 2020 cases. And I guess the additional argument is that unlike the government sentencing memorandum, defense argument is that there's even greater chance she would have read the plea agreement before entering it. But I'm assuming that the state's argument, well, I don't want to assume. Does the state want to make any argument about 403?
I think it's still kind of the same argument. I think with the addition of that information, I guess we'll just point out again, you have to know that she was considering that, recalling that, or even remembered that. It's been a couple of years at the time that she received the DOJ letter. Between the time she read it, or as she put it, skimmed through it, and testifying, and that she was putting that together, that she was considering that information that she may or may not even recall.
Okay. All right, let's plan to be back on the record at 9 tomorrow. If the attorneys could please get here about 10 minutes early, it just helps facilitate starting on time. And we'll break for today.
Oh, Judge, I'm sorry.
What?
I'm sorry.
All right.
We all want to leave. I'm so sorry.
Okay, that's right.
I wanted to add to that. That letter was from a state DOJ. And so it's conceivable too that she doesn't know where she's being prosecuted. She doesn't know whether it's the state government or the federal government that's prosecuting her. There's no indication of what charges she's actually being charged with and whether that's going to be state or federal. So how would she know for certain what her exposure would be in federal court or state court, because she doesn't even know necessarily where she's being prosecuted.
And Your Honor, I would just remind the court that we are calling Aaron Jeffers tomorrow, and he's going to address the state part of that.
And remind me when Mr. Jeffers will be here tomorrow, or do you know?
We would plan to call him after Ms. Maddox because she has the death in the family, and we didn't want to keep her waiting in the hallway too long.
That's right, okay. All right. Okay, we'll be in recess.
All rise.